to commence with the final round of arguments.
Yes, we can hear the applicants and both teams should take it. I hope you're all right with this, Justice Chagla. Take the facts as read.
Yes.
Yes, the applicants, please.
Yes, Your Excellency. With your permission, if I could just begin with a few housekeeping matters. I'd just like to set out our intention as to how myself and my co-agent will split up the argument. With your permission, we intend to address questions 1 and 3 together. So the question of jurisdiction and the question of provisional measures. And I'll be addressing those points, and my co-agent will address the second question as to the admissibility of Ms. Catania as an expert witness. And if that's all right with Your Excellencies, I would like to begin with the first question before this court with respect to this court's jurisdiction under Article 17 of the Peace Treaty. Now, it is our submission that this court does indeed have jurisdiction under Article 17 for 2 reasons. First, the language of Article 17 ought to be understood in a flexible and dynamic fashion, so as to include cyberspace and cyberspace operations. And secondly, notwithstanding that former point, the language, the territoriality of the particular acts which Ryanshan is alleged to have committed, make it so that they fall within the scope of the term, quote, territorial sovereignty. Now, turning to that first point with respect to the dynamic interpretation of the treaty, we would submit that the language of territorial sovereignty as used in Article 17 is a relatively vague term, a general term, and it is one which this court has often taken to be something which might evolve with the legal context. So in the GLC case, for instance, this court understood a relatively analogous phrase with respect to territoriality as one which is subject to an evolving interpretation. And if Your Excellencies could turn to page 2 of the Iadrian Memorial.
Yes.
We addressed that term in our memorial. So in the Aegean Sea, the analogous term was, quote, relating to the territorial status. That was understood as a general term capable of an evolving interpretation. And here the relevant passage is, quote, territorial sovereignty. Second, contrary to the notion that cyberspace is somehow lawless in the international context, that it is that territorial sovereignty cannot be understood to include such operations. The UN general, the 2015 group of governmental experts, for instance, have adopted the notion that state sovereignty and international norms apply to the conduct of states in these activities. And as such, we would submit that at minimum, in principle, cyberspace operations are capable of falling within the term territorial sovereignty. Now, at this point, the IADRI would like to address a fundamental point of principle. At least as we understand it, there is a fundamental distinction between an adjudication of jurisdiction and an adjudication on the merits. That fundamental distinction can be found first in this court's statute. So if I could turn Your Excellency's attention to Article 36 of this court's statute, jurisdiction is defined under the statute as comprising all cases which the parties refer to it. And if I could then turn Your Excellency's attention to Article 17 of the Peace Treaty, a treaty which no one disputes, both IADRI and Ryanshan are a party. The operative phrase is, quote, any dispute regarding a violation of territorial sovereignty. It is our submission, therefore, that the question as to whether this court has jurisdiction under this treaty concerns a matter of whether or not the subject matter of the complaint, which IADRI alleges, falls within the meaning of territorial sovereignty. Now, there is, of course, an additional question, which we don't dispute, we will eventually have to establish, which is whether or not the acts of Ryanshan, or whether or not the acts of certain third parties, like the pandas or other hacking collectives, are attributable to Ryanshan given their potential control or supervisory function over those groups.
Yes, I just have one question. When you talk of, and it's mentioned in Article 17, that there has to be a violation of territorial sovereignty. When you talk of violation, first you define what is territorial sovereignty and then talk of the violation.
Yes, Your Excellency. So it is our position, at least, that the wording is that it's a dispute regarding a violation of territorial sovereignty. So there's an alternative way that the parties might have phrased Article 17, which would raise more issues. So that alternative phrasing might be something along the lines of saying, quote, the parties hereby agree that any violations of territorial sovereignty shall be resolved by referring the matter to the International Court of Justice. But that is not the language that the parties chose to use. The parties chose to use the language of disputes regarding a violation of territorial sovereignty. So long as IADRI can at least allege actions which putatively are attributable to Rianchin and are alleging them in such a way that the subject matter falls within the meaning of the term territorial sovereignty, we would submit that this court would have jurisdiction to hear the case. And this is sensible, we would submit, Your Excellency, because otherwise there would be nothing to adjudicate on the merits. Everything would collapse to jurisdiction. We would have to address every issue with respect to whether or not the act is an internationally wrongful act at the jurisdiction phase. And then we would have nothing left to address at the merits phase. And that just procedurally will be much more hard to work around. So it makes perfect sense why the party chose this language. And it is one that this court should adopt and respect. Now, secondly, I'd like to turn also to the notion of territoriality. So there appears to be a general sense, at least 10 or 20 years ago, that cyberspace is somehow unbounded by the natural world, that it doesn't have natural limits or that it doesn't have boundaries, but that's simply not true. The language of the cloud, for example, is one where it's reminiscent of something floating above in the air, but really the cloud and the information stored in the cloud is stored on physical servers. So they're physical computers and they have a physical location within states. And here, the physical servers that are relevant were located within the boundaries of IADRI's territory. Now, beyond that, we also think that there are two specific acts which Rianchin has committed, which we think are sufficient to trigger the territoriality element or to make it such that it's territorial sovereignty. Those two acts are, one, Rianchin downing and destroying one of IADRI's drones, and two, Rianchin disabling the firewall. Now, in their memorial, Rianchin also, much like us, relies on Talon 2.0. And the two acts I mentioned fall squarely within Talon 2.0's understanding of a violation of territorial sovereignty. So turning first to the drone, the destruction of the drone is physical damage within the meaning of Talon 2.0. Here I'm referring to page 20 of Talon and paragraphs 33 of the Statement of Agreed Facts. Now, by destroying that drone, Rianchin has destroyed physical property which IADRI owns, and it's done it in an area which is at least alleged to be falling within IADRI's territorial boundaries. And so on paragraphs 33 of the Statement of Agreed Facts, it's somewhat ambiguous as to where exactly the drone fell or where exactly the drone was destroyed. We know that it was destroyed within the line of factual control, but we don't know whether it was on IADRI's side of the line or Rianchin's side of the line. But it is our submission that at least at this preliminary stage of litigation, it doesn't matter which side of the line the drone fell, precisely because there's a fundamental distinction in international law between lines of factual control and the bounds of a state's territorial sovereignty, the territorial boundaries of a state. IADRI at least certainly claims more than just merely the line of factual control as its legitimate borders. And at least at this stage in the litigation, we would submit that it's sufficient that we demonstrate that the drone was destroyed within the boundaries of IADRI's claimed territorial sovereignty. Again, now turning to the second act that we talked about, the firewall, we would submit that again, it squarely falls within Talon 2.0's understanding of territorial sovereignty. Again, at page 20, Talon talks about a loss of functionality as to critical cyber infrastructure. The firewall is cyber infrastructure. It protects critical cyber infrastructure. It forms a part of that system. And by disabling the firewall, by essentially depriving it of its function, it was certainly an act which caused it to lose functionality. Now, the disabling of the firewall is discussed at paragraphs 37 and 38 of the Statement of Agreed Facts. And on those facts, it's quite clear that it is the Rianchinian army, which is responsible, directly responsible for the disabling of that firewall. And so taken together, we would submit that these two acts at minimum are violations of territorial sovereignty under the meaning of Article 17, and that they are sufficient to fall within the jurisdictional wording of Article 17 of the treaty. And if your excellencies don't have any questions on that point, I would request permission to move to the third question before this court.
Carry on.
Yes, your excellency. So turning to the third question, which concerns whether this court ought to indicate provisional measures. Again, we think that there are four issues at stake. First, whether this court has prima facie jurisdiction. Second, whether this court, whether the rights which IADRI alleges fall within its subject matter and is plausible. Third, whether there is irreparable injury. And fourth, whether it would prejudice the merits. So turning to the prima facie jurisdiction, if your excellencies would turn to page 13 of the memorial, IADRI's memorial, we discussed the general jurisprudence of this court, which is now a long-standing one, that all we must show at this phase is prima facie jurisdiction, that there is a plausible basis on which this court might have jurisdiction. Now, obviously, just a few minutes ago, I made the case that we have a very strong argument for this court's jurisdiction, but at least on this issue, as to whether this court ought to indicate provisional measures in the interim, all we must demonstrate is a plausible basis. And we think that we've shown this by pointing to Article 17 of the treaty. Now, second, as to the nature of the rights in question, in their memorial, Ryanshan has argued that the nature of the rights is one in which IADRI's assertion of its interest over the documents just isn't a plausible basis on which IADRI might have rights over the document. Now, we think there are two reasons why this submission will not work. First is if I could turn your excellency's attention to the Timor-Leste case. This is the most recent case on which this court addressed an analogous set of facts. In the Timor-Leste case, this court discussed two possible avenues by which Timor-Leste might have had an interest in the documents at stake. So in this case, essentially, Australia had seized Timor-Leste's documents in its territory, within Australia's territory, and that those documents might have had a prejudicial impact on ongoing arbitral proceedings, much like in our case. And here the court discusses two possible avenues by which to ground the claim for preliminary measures. First, and we don't dispute that this isn't relevant, the court discusses the right of confidentiality in communications with its legal advisors. But more relevantly, the court discusses the notion that Timor-Leste has a right to non-interference with ongoing arbitral proceedings. And we think that this is sufficiently similar to ground the right in this case. Again, Ryanshan and IADRI currently have outstanding arbitral proceedings. These documents, no one disputes, might have an adverse effect on IADRI's position in those arbitration proceedings. And indeed, Ryanshan has threatened to use the information contained within these documents within those arbitral proceedings. And so we do think it falls squarely within the meaning of the interest defined by this court in Timor-Leste. And second, and alternatively, we think even if you don't find this interest compelling, ultimately, the question of whether IADRI has a right of property over its documents is a question of customary international law. But customary international law is not the only source of law that this court must consider. There's also, of course, the treaty language. Treaty language can confer rights over documents. And here we would submit that the Article 17 of the peace treaty, by using the language of territorial sovereignty, gives IADRI interests or rights over documents which fall within its territorial sovereignty and in which you would have to breach its territorial sovereignty in order to extract. And so we think in either avenue, this court, there is a plausible basis for the rights which IADRI claims over the documents for which it seeks provisional measures. Now, third, we'd like to address irreparable injury. In their memorials, Ryanshan has claimed that the reason that there might not be irreparable injury in this case is because Ryanshan might give assurances that it wouldn't use this information or that it wouldn't leak this information. We think this is insufficient. Turning your excellency's attention to, again, the Timor-Leste case. This is paragraphs 43, the court explicitly acknowledges that the Attorney General of Australia was willing. I'm sorry, Your Excellency.
No, go ahead.
Oh, the court was willing to that the court explicitly noted that the Attorney General of Australia was willing to give written communications, the written commitments that it wouldn't use the information in the way that Timor-Leste feared. But if you go down to paragraph 47 of the order, the court explicitly acknowledged that while that might bear on the magnitude of irreparable injury, it does not fully address it, and that the possibility of irreparable injury still stands in a way which is sufficient to ground the claim for provisional measures. And here we would submit that the case is actually even weaker for Rianxon than in the Timor-Leste case.
Agent, could you go up to the previous paragraph, please, of Timor-Leste?
Yes, Your Excellency.
Were the documents of which the Attorney General in Australia was speaking, were these documents obtained legitimately?
Yes, Your Excellency. So actually, there's a question. So on the facts of Timor-Leste in Australia, there was a live question as to whether these documents were obtained legitimately. So as a matter of domestic
where the documents were obtained illegitimately or surreptitiously, the question of an undertaking or of using them for bona fide purposes would not arise. I mean, that's a point in your favor, surely.
Yes, Your Excellency. So that's what I was getting at, is that in at least Timor-Leste's case, it was more ambiguous because it was done, the documents were seized within Australia's territory pursuant to a valid search warrant.
Great.
Whilst in our case, there is none of those mitigating factors. And so the issue should be quite clear that IADRI does in fact have a legitimate interest over these documents. And so we think, the court granted provisional measures in Timor-Leste, and we think the case in all material respects is actually quite stronger in our favor on the present facts. And finally, with respect to the prejudicing the merits, it appears that the contention might be that by granting provisional measures, this court would prejudice the merits because it would require Rianxon to destroy its copies of its documents. We think that this claim is fundamentally misconstrued, precisely because there's no destruction going on. Ultimately, the IADRI does not request that this court destroy all evidence of the Panda papers or the information within it. We simply ask this court to take possession of those documents themselves so that the court can preserve its ability to reach a final.
Wouldn't you have to first satisfy as to whether Rianxon was directly involved with the cyber warfare which they've carried out? Or, because as per the fact sheet, it's really the Pandas who is the one responsible. And in fact, with regard to the IP sites, and it emanated from the Pandas. Now, so far as Pandas and Rianxon is concerned, there is a link, no doubt. But doesn't one have to really satisfy that Rianxon has actually taken this material?
So 2 points, Your Excellency. First,
Yes.
We don't think at this preliminary phase we would have to demonstrate that Rianxon, that the Panda's actions are attributable to Rianxon, because again, we think that is a question on the merits. But with respect to jurisdiction, at least we think we've given sufficient information to show.
No, 1 minute. Just hold on. Provisional measures. You're asking for provisional measures. Now, for provisional measures, wouldn't you have to satisfy that?
We don't think we'd have to satisfy that. So essentially, the court's longstanding practice has long been to say that the merits, the likelihood of success on the merits, is not relevant with respect to provisional measures. The court recently has taken a slightly more strict line and said that the plausibility of the merits might be in question. But again, on whatever standard you choose, it is not a question of whether we can definitively establish that Rianxon is responsible, just whether we've raised sufficient, whether we've had a plausible case for Rianxon's responsibility. And the facts that Your Excellency referenced with respect to the Bitcoin, with respect to Rianxon's past supervision of the activities of these Panda papers, of these Panda groups, as you might find in paragraph 16 of the Statement of Agreed Facts, we think that is sufficient at this stage. And also, with respect to the nature of the claimed interest, given that IADRI is claiming a proprietary interest over these documents, with respect to the provisional measures, the mere possession that Rianxon has admitted to, that Ryanshan possesses these documents, is sufficient to ground its being liable to at least these provisional measures before the court can reach the merits and finally and definitively adjudicate on whether there's an attribution of responsibility for Ryanshan. Thank you, Your Excellencies. And if there are no
very much. Thank you very
Yes,
much.
thank you.
Thank you.
Yes.
Thank you, Your Excellencies. I am the co-agent for the state of Ayadri, and over the course of the next 10 minutes, I will be dealing with the second issue in this case. In short, Ayadri argues that there is no need for this court to take the extraordinary step of rejecting the appointment of Ms. Catania as its ex parte expert. This is because there is no reason to think that her introduction would bring about the recusal of Judge Guran, and even if it did, the lack of quorum that would follow could be remedied by the establishment of an ad hoc chamber. This argument consists of 4 submissions. First, that there is a very high bar for interference with the party's right to appoint its own expert. Second, that very high bar is not met in the present case. Third, that to require recusals in such circumstances would lead to unworkable consequences as a matter of judicial administration. And fourth, and in any event, that even if Judge Guran were recused or removed, the lack of a chamber could be set up to address the lack of quorum. Turning then to my first submission, that there is a very high bar with parties' right to appoint its own experts is shown by the fact that this court has only interfered with it 3 times. And if Your Excellencies turn to page 7 of our memorial, you will see moreover that such interference has always been in extraordinary circumstances, from where the expert witness has already been included as an advisor in the list of a delegation representing the same states, to where the evidence is simply not going to be of use to the court at all. And this high bar we would submit is consistent with a party's general autonomy to present their case in the manner they choose. But our second submission is that this very high bar of interference is not met by the alleged conflict involving Ms. Catania. There is no reason to think that her introduction guarantees or even makes remotely likely the recusal or removal of Judge Guran. And that is so whether the initiative for recusal were to come from Judge Guran or whether it were to come from Ryanshan. To take the case of self-recusal first, it is of course true that a personal relationship which gives rise to an appearance of bias has previously been given by judges as a ground for self-recusal. However, we would submit that those cases are so far from the present case that it becomes clear that the connection, such as it is between Judge Guran and Ms. Catania, is wholly insufficient to lead Judge Guran to recuse himself. And we would submit that the 3 examples that we cite on page 9 of our memorial demonstrate this perfectly. That, for example, in the Anglo-Iranian oil company case, the judge recused himself on the ground that he had represented India in the Security Council when the same dispute was discussed. In the Nottingham case, on the ground that the judge had previously advised one of the parties. And in the third case, in the advisory opinion, Judge Bazdovo recused himself on the ground that the president of the tribunal to be reviewed was his own daughter. But I think Your Excellency,
I have a question here. It's
yes,
a matter of theory, really. When a party wants to call a particular witness, an expert as a witness, is it not correct, and I don't know what the authority for this is, that it is the right of the party to call that witness that must receive precedence and primacy over the question of whether a tribunal should have this or that judge sitting on it? Between these two, it's not the presence of the judge on a particular tribunal that gains priority or precedence over the right of the party to put its best case forward in the manner it believes most appropriate. If that is so, surely you would argue, and there must be some precedent, that a bench must yield to the requirement of the party, and if there is a conflict of interest, then the bench must do what the bench must do.
Indeed, Your Excellency, and that is why in our fourth, in my fourth submission, I say that a satisfactory option for this court, if Judge Guran, for example, chose to recuse himself, would be the establishment of an ad hoc chamber. So that was.
Well, let me put that differently. If your witness is disallowed on the basis that there is a potential bias in Judge Guran, what's your plan B? And can you be left in a situation where you don't have a fallback position or a fallback plan simply because the judge says, I won't allow that witness and I won't recuse either? That's surely jurisprudentially unacceptable. I mean, that's definitely a point in your favor that the judge must yield.
Sorry, if you just is this a
Surely
question?
the judge must yield because it's the right of every party to be able to put forward its best case in the best possible manner.
Yes, we would absolutely.
I mean, what is your plan B if your witness is disallowed and is not allowed to give testimony, and because there's a conflict with Judge Guran, what option do you have left? Or can you be forced to a second-tier witness?
I don't think that such a move would be consistent with our autonomy to, as Your Excellency puts it, arrange our case in the manner in which we choose. And moreover, Ms. Catania is one of only two witnesses in the world to have published papers on the intersection of public international law and cyberspace, and she is essential to our case. And undue interference with our right to appoint her would, as Your Excellency says, be completely unjustified. If I may proceed.
Yes, please.
Thank you, Your Excellency. Turning to the second recusal scenario, where Rianchan were to request under Article 34 Judge Guran's removal under Article 24 of the statute, we would submit that this too would have no prospect of success, as it would be manifestly inconsistent with this court's jurisprudence. To take the case of Wall Opinion, which is the most recent case of a party requesting the removal of a judge on account of his or her professional experience. In that case, the court, by 13 votes to 1, rejected the mooted appearance of bias standard in favor of a standard of previous participation in the case. Now, on our facts, Judge Guran has clearly not taken part in the case. And the only basis on which the respondents in their memorials impugn Judge Guran's position is his prior professional experience. And this would clearly fall outside the interpretation of Article 17, which this court adopted in Wall Opinion. And so Wall Opinion repudiates the position taken by the respondent in their memorial that for Judge Guran to continue to sit on this case would somehow violate the principles of natural justice. I'm aware of my time is expiring, so I'll turn now to my fourth and final submission, which is that even if Judge Guran were recused or removed, this court could, under Article 26 of the statute, form an ad hoc chamber to hear this particular case. And while it is true that the formation of such a chamber requires the consent of both parties, we would submit that Rianchan would not be entitled to withhold its consent. This is because Rianchan cannot, at the same time as requesting that this court disqualify Ms. Catania on the ground that allowing her would lead to a delay, it cannot at the same time refuse to participate in this procedure, which would eliminate the risk of that delay. Rianchan cannot rely on a problem of its own making. And we would submit that this point is reinforced by the fact that in its memorial, the respondent claims that allowing Ms. Catania to testify would violate its right to a speedy trial. And so their consensual participation in the formation of such a chamber would address that concern and would, we believe, facilitate a speedy resolution of these matters. And I would request one more minute to just make one further point. Thank you very much.
Yes.
Just one last point, and it is a practical one, which is that if this court were to accept Rian Chan's position, then unworkable practical consequences would follow. And this is because the rationale behind Rian Chan's argument would also apply to counsel. That is to say, if a judge, having once worked in the same law firm as a witness or expert, is deemed enough for his or her recusal, then there is no reason why a judge, having once worked in the same law firm as one of the counsel before the court, should not also bring about his or her recusal. And this position we submit is impossible if this court wishes to maintain the current very high caliber of judges that it has at its disposal, since for a judge to have worked in the same law firm, same successful law firm as a counsel would be a very common occurrence. And so Rian Chan's position would strain the court's resources and severely hinder the workability of its administration. So just to sum up very quickly on the second issue, that we submit that it is unnecessary for this court to take the extraordinary step of rejecting the appointment of IRG's expert witness, and that in effect, Rian Chan's approach would deprive the law of all coherence. It would deprive the word bias of all meaning, and would in time deprive this court of all its justices. And that concludes IRG's submissions on the second issue.
Thank you very much.
Yes, thank you.
Rian Chan?
Before I proceed, Your Excellencies, I hope I am clearly audible and visible to you.
Yes, go ahead.
Much obliged, Your Excellency. Good evening, Your Excellencies. We appear on behalf of the respondent for this case, the People's Republic of Rian Chan. I will address the respondent's first issue regarding whether this court has jurisdiction on the merits of this case, and the second issue regarding whether Ms. Catania can be appointed as an expert witness. Subsequently, my co-agent will address the third issue regarding Ayadri's request for provisional measures. Your Excellencies, Ayadri and Rian Chan are two neighboring countries which from 1960 to 70 were engaged in a brutal war that finally ended in the brokering of the
Sorry, Agent, there's some problem with my video feed, so if it goes off in between, don't let that stop you. Just want to tell you that.
Oh, absolutely, Your Excellency.
Carry on.
Which finally ended in the brokering of a peace treaty in 1972. This treaty led to a period of robust economic cooperation that was encouraged by the Arbit. However, in 2020, Ayadri, in absolute violation of the Arbit, banned 273 Rianchanian apps, thereby severely crippling several Rianchanian businesses and investors. Recently, Rian Chan has received a disturbing report from an anonymous source, which reveals in no uncertain terms that the app ban was a calculated move to stymie Rian Chan's boosting economy. Rian Chan wishes to produce these documents at the oral hearings for the arbitration in March 2022, but the same is being blocked by Ayadri wrongfully through these proceedings. In light of these facts, the issue arises whether this court has jurisdiction under Article 70 of the Peace Treaty, which reads as, to avoid a repetition of circumstances that brought about this treaty, the parties hereby agree that any dispute regarding a violation of territorial sovereignty between them shall be resolved by referring the matter at the request of either party to the International Court of Justice. Your Excellencies can find this on page 18 of the Moot proposition. Following the structure of the applicant, we will respond in two parts on how this court does not have jurisdiction. First, whether Ayadri's territorial sovereignty has been violated. Secondly, whether the attacks are actually attributable to Rian Chan. Responding to the applicant's first submission, Ayadri's territorial sovereignty under Article 17 has not been violated. The applicants on page 15 argue that an evolutionary understanding of the term territorial sovereignty must be adopted to include cyberspace by heavily relying on the Aegean Sea continental shelf case, which they do so in their oral submissions as well. However, we take this liberty to distinguish this case because of the facts. We must note, Your Excellencies, that the cyberspace in its nature is vastly different from the issues that were dealt in the case of the Aegean Sea continental shelf, where this court had dealt with abutments to land in the form of continental shelves, which we might add, Your Excellencies, had already been recognized as part of a state's territory through years of custom.
What's the great distinction between cyberspace and other forms? What's this distinction that you're drawing?
Absolutely, Your Excellency. The distinction that we draw is that the cyberspace, considering that it is a global commons and it is essentially a metaphysical space through which you cannot draw boundaries per se. And moreover, there has been lack of state practice, let alone custom to support as to if and to what extent can we include cyberspace within the ambit of territorial sovereignty. We submit that an evolutionary understanding of the term territorial sovereignty within Article 17 cannot be adopted.
Are you saying that because according to you, it's only physical territorial sovereignty? It cannot be done through interference with the sovereignty indirectly by means of cyberspace?
Your Excellency, considering the fact that considering the object and purpose of the treaty and the context in which it was created, we submit that such an interpretation of territorial sovereignty was never envisaged by the parties in the first place. If Your Excellencies turn to the preamble to the treaty specifically, if Your Excellencies, for your convenience, shall we share the relevant portions? Yes, just a minute. Yes. So, Your Excellencies, if you could draw your attention to the first line, desiring to find a negotiated solution to the situation in the Kailasa region is, and this line specifically states that this was in accordance with the war that had broken out in Kailasa region and to prevent any further conflict in the border region between Ayadri and Rianchan. Then again, if you turn to your attention, Your Excellencies, to the next line, which is desiring to lay down means for avoiding further tensions along the border. This is in the next paragraph, Your Excellencies, designed to lay down means for avoiding further tensions along the border in the form of continuous dialogue and a procedure for resolution of disputes. Again, this line, Your Excellencies, clearly states the entire scope of the treaty in the sense that when it was brokered, we only envisaged border disputes and no more than that. Hence, considering that even if we take a holistic interpretation of the treaty, taking the preamble and the compromissory clause, which is Article 17 in this case, we still do not arrive at a finding that the cyberspace is included within territorial sovereignty. If that answers your question, Your Excellency.
Yes, go ahead.
Much obliged, Your Excellency. Considering now, however, for a moment, even if we accept the applicant's contentions at the highest and say that, yes, cyberspace is a part of Article 17, even at that moment, the applicant's territorial sovereignty as per Article 2, Subclause 1 of the UN Charter has not been violated because the cyber attack had minimal impacts on Ayadri's ICT infrastructure. In order to determine jurisdiction, it is important to enter into a prima facie evaluation of the relevant facts and laws which are relevant to this issue in accordance with Rule 79 of the Rules of the Court, which is opposed to what the applicants contend in their oral submissions. Essentially, what happens is that if we rely on the Talon manual, which the applicants also do so in their oral submissions, it clearly states that the threshold for the violation of territorial sovereignty must be a loss of functionality or physical damage. Any attack that is below the threshold is not violative of territorial sovereignty. Your Excellencies, it is our submission, therefore, that the hack into Ayadri's cyber networks has not resulted in any physical damage to the ICT infrastructure, property, or citizenry. The mere placement of a malware into its servers, leading to the exploitation of its data, the very nature of phishing attacks, which are very low scale in nature. If you turn your attention to paragraph 36.
Agent, careful with that argument. Are you accepting responsibility for all of this?
No, Your Excellency.
Because it has, every action will have a consequence. If you are accepting the responsibility for the malware and the phishing attacks, and the fact that the IP addresses were traced back to your territorial region, then you may have serious problems here.
Your Excellency.
How are you structuring your response given that?
Apologies, Your Excellency, for interrupting you. We were actually going to deal with that submission in the second limb of our argument.
All right, fair enough.
Shall I proceed
Fair
to
enough.
the second limb?
Fair enough. All right.
Much obliged, Your Excellency. So, Your Excellency, coming to the second limb, Rianshan cannot be held responsible for these cyber attacks in Ayadri as they were carried out by a non-state actor. Your Excellencies, in fact, had posed a very valid question to the applicants as to whether Rianshan, whether we can attribute these cyber attacks back to Rianshan. But the applicants had replied by saying that these considerations we cannot enter into in the preliminary objection stage. However, on the contrary, what we submit that that Ayadri actually has a fundamental burden right now to discharge, which is to prove attributability. Because if it cannot prove attributability in this case back to Rianshan, then Rianshan cannot be made a party to this dispute under this treaty. What we tell you today, Your Excellency, is that we have always maintained that these documents were sent to us by an anonymous source. We do not know who has sent it, and we have no links whatsoever with this anonymous group. Considering these facts, we submit that since an action by a non-state actor under Article 2 of the UN Charter is not something that can violate territorial sovereignty, because the principle of respect for territorial sovereignty is something that only bound states in their mutual relations, we submit that Rianshan cannot be held attributable for these attacks at all. Ayadri, by failing to discharge these burdens, tries to rely on a very unreliable piece of investigative report that it submits today. We do not wish to disseminate in full their investigative report, but just a prima facie dissemination also shows us that, in a sense, this investigative report is extremely unreliable due to its high reliance on using IP addresses to determine the identity of the attackers. Considering the myriad ways in which hackers feign their identity on the cyberspace through IP spoofing and so on.
Let me just ask you a question. Just come back to Article 17 for a moment, please.
Yes, Your Excellency.
There are 4 keywords here: dispute, violation, territorial, and sovereignty. Are you taking the position that this becomes jurisdictionally competent, this dispute, only if it is established that the action is a sovereign action, that is by a state actor acting within its territory or crossing a physical boundary, and thus violating the other party's territorial or boundary integrity? Is that your position? It has to be a state actor acting from its boundary across in a trans-border kind of fashion. Is that the position you're taking?
Yes, Your Excellency.
All right.
Much obliged. So this right now concludes our submissions for issue 1, unless Your Excellencies have any further questions.
That's fine. Carry on.
Much obliged. Your Excellencies, this now brings us to the second issue. Currently, Ayadri has called for Ms. Daisy Catania to appear as an expert witness for these proceedings. However, this court must note that Ms. Catania was a junior partner, while Judge Quran was a senior partner at the same time in Kulshesht LLP. And this association would inevitably cause Judge Quran to recuse himself. In light of these facts, we'll respond to the
answer. A question to that is, so what? If he recuses, he recuses. Happens all the time. What's the great loss? There's no real shortage of judges, is there? There's a distinct shortage of expert witnesses. There are only 2, we are told.
On the contrary, Your Excellency, in these current circumstances, the recusal of Judge Quran would lead to a lack of quorum because the ICJ has been unable to make judge appointments for the past few months due to the Omicron and COVID situation. If that satisfies your question, Excellency.
Well, I suppose it'll have to do. All right. Yes.
So, if I may proceed.
Yes, please.
Responding to the applicant's submission, we will address the issue of whether the appointment of Ms. Catania as an expert would make Judge Guran's recusal a fait accompli in 2 parts. First, natural justice and the right to fair trial would be affected in the event of Judge Guran adjudicating where Ms. Catania is an expert witness. And secondly, Judge Guran and Ms. Catania's past relationship falls within the ambit of Article 24 of the ICJ statute. Responding to the applicant's submissions, the right to free and fair trial and natural justice, which are recognized as general principles of international law, would be violated if Judge Guran participates in this case with Ms. Catania as an expert witness. The independence of the expert witness and the judge is a sine qua non of any international adjudication in order to preserve the rights of free and fair trial and natural justice and to preserve the sanctity of these judicial proceedings. Now, the applicants in their written submissions in page 19 to 24 have admitted that this court has limited jurisprudence surrounding recusals because it is very uncommon. But it has also used this as an excuse to set a very narrow understanding of the circumstances under which a recusal may take place. However, if we examine the existing rules and standards set in international adjudication, the practice is that in various international courts and tribunals, even past professional associations were taken into account to warrant recusal. This was seen, for instance, in the case of Amoco Iran, the Islamic Republic of Iran, 1988 Iran-US Claims Tribunal, where Judge Breiner had to recuse himself since he had a close relationship with the Swiss subsidiary of Morgan Stanley, whose employees were appearing as expert witnesses on the case. Further, in Rapska Elektroprivreda v. Slovenia, 2008 ICSID, it was ruled that a barrister sitting in the same chambers as the president of the tribunal must be excluded from representing one of the parties due to the bias that is created in this situation. It is our submission that there are justifiable doubts created in the eyes of a reasonable and informed third party as to Judge Quran's independence when Ms. Catania is an expert witness. If we apply the principles behind Judge Breiner's recusal to this case, it cannot be expected that Judge Quran would be impartial in his treatment of Ms. Catania, considering his past association with her. Alternatively,
Are you saying that merely because they knew each other several years ago, they worked in the same firm? Are you saying that because of that, Judge Quran can't express an independent mind or will be biased?
Your Excellency, considering the fact that Judge Guran was a senior partner and Ms. Catania was a junior partner, moreover, they have both an interest, or say they've both dealt with public international law, and hence it is very reasonable to conclude that they would have interacted a lot when they were in the same firm. Hence, it is reasonable to conclude that Judge Quran might be influenced to a certain extent or might be biased to a certain extent when Ms. Catania is involved in the proceedings. If that answers your question.
But Agent, Judge Quran is only one of several judges on the tribunal. Surely he doesn't have a determinative say. What difference will it make? It's a witness. It's not going to be pivotal one way or the other. And yours is merely an apprehension of some unspecified bias. Is that enough to dislodge the introduction of a witness entirely?
Your Excellencies, we have 2 responses to that question. Firstly, the vote that Judge Quran will have, his opinion and his vote will matter in the case subsequently in deciding the verdict or the judgment of this case. Secondly, on a balance of equities, Rianshan has a greater right of natural justice and free and fair trial as opposed to a Yadri's right to present an expert witness in a proceeding. Your Excellencies have also mentioned that there is another expert witness who is there, who can be brought to these proceedings. On a balance of equities, we request this court to consider the matter. Your apologies, Your Excellency, seeing as my time is running out, can I ask for an extension of a minute?
Yes.
Much obliged, Your Excellency. Does that satisfy your question, Your Excellency?
Well, you don't have the time to expand on it, so carry on.
No, if
So just
I
go
need
ahead.
any more
No, you
clarity.
carry on with your argument.
Just go ahead.
Okay, much obliged. It is therefore we submit that it is much more desirable to let Ms. Catania to prevent Ms. Catania from coming to these proceedings, because a lack of quorum would take much time to remedy. Even the solution of ad hoc chambers that the applicants provide would take much time to also form, and we need to present, considering that we need to present this evidence at the arbitral hearings in March, we submit that it is important that these proceedings are held expeditiously. Turning to my second limb, Ms. Catania's appointment would consequently lead to Judge Quran's recusal as per Article 24, because of the term special reasons used in Article 24, which envisages even personal and professional associations within its ambit. It is our submission that since the independence of Ms. Catania can't be proved in these circumstances, considering that she was a junior partner when Judge Quran was a senior partner, and also the fact that they have engaged and interacted on common issues surrounding public international law, we submit that Judge Quran's association would fall under special reasons, which is mentioned in Article 24, to warrant his recusal. Thus, in conclusion, we submit that Ms. Catania has to be excluded from these proceedings. Unless Your Excellencies have any further questions at this point.
No, that's fine.
Yes.
Much obliged. Thank you so much, Your Excellencies. It was an honor to argue before this bench. My co-agent will now take you through issue 3. Thank you.
Before I begin, Your Excellencies, am I clearly audible and visible?
Yes.
Yes.
A very good evening, Your Excellencies. I am the co-agent for the People's Republic of Ryanchan. Over the course of the next 12 minutes, I will address the respondent's third issue regarding Ayadri's urgent request for the provisional measures. Your Excellencies, following the structure of the applicants, we will respond in 2 parts on how Ayadri's urgent request for the provisional measures regarding the documents must not be granted. First, we will explain how the rights asserted by Ayadri on the merits are not plausible, neither is there a prima facie jurisdiction. Second, we will show that there is no risk of irreparable prejudice and urgency. Your Excellencies, according to established jurisprudence, this court indicates provisional measures provided a few requirements or criteria are met. It must be noted that if these requirements are not met or satisfied, then this court does not provide the indicate the provisional measures. Your Excellencies, turning to the first limb of my argument, the applicants have claimed in page number 14 of their argument section in the written memorial that they enjoy certain rights which fall within the subject matter of the proceedings. In response to that, it is our submission that the rights asserted by Ayadri on the merits are not plausible. Now, plausibility of the rights is one of the criteria which this court checks in order to grant provisional measures. If the alleged violations of the rights which the applicants claim, if they do not exist in fact, then this court considers that such claims are not plausible. Your Excellencies, in its order in provisional measures in the case of Ukraine versus Russia, which came before this court in the year 2017, this court found that it needs to decide whether the rights claimed by the applicant on the merits of the case are plausible. In order to do so, this court decided that if the acts which are alleged by the applicant state fall outside the ambit of the treaty, of whose violation the applicants are claiming for, then the rights claimed by the applicant cannot be plausible. In the case at hand, if we relate it with the facts of the case, the treaty in concern is the peace treaty and the clause is Article 17. In that regard, if we relate with the facts, we submit that the rights which are claimed are not plausible. We have further dealt with this extensively in page number 11 of the arguments advanced section of our memorial. Your Excellencies, all the materials which are described in Ayadri's application, including the cyber attack on the Ayadrian offices and the alleged direct responsibility of Ryanchan, fall outside the ambit of Article 17. In order for there to be a breach of territorial sovereignty under the peace treaty, even for once, if we accept the highest claim of the applicants that cyberspace is a part of territorial sovereignty, then also, in order for that criteria to be satisfied, the required criteria for unlawful use of force has to be satisfied. We will place our reliance on the Talon manual, which has also been extensively used by our applicants in their oral submissions as well as the written memorial. So in rule number 4, point number 11 of the Talon manual, it was said that in order for a cyber attack to be unlawful, there has to be 1, physical effects, and 2, loss of functionality. Your Excellencies, neither of them have happened in this case. Cyber operations necessitating replacement of the physical components alone refer to physical damage. In this case, there has been no such damage, Your Excellencies. In fact, the applicants mentioned that there has been a disabling of the firewalls, but firewalls are merely a software issue and not a physical one, Your Excellencies. Furthermore, there has been no loss of functionality as well, according to the agreed statement of facts. Hence, the test for cyber operations to be an unlawful use of force is not met in this case. Thus, it is our submission that as all matters described in Ayadri's application fall outside the ambit of the peace treaty, the rights which are asserted by them are not plausible. Furthermore, Your Excellencies, the applicant in page number 14 of the written memorial have submitted that there has to be a relation between the rights to be protected and the measures which are requested. It is our submission that there is a lack of linkage between the measures which they have requested and the rights which they are claiming for. Your Excellencies, if you refer to paragraph number 40 of the Moot problem, Ayadri has been claiming that there is a violation of their territorial sovereignty. That is by no means linked to the provisional measures which they are requesting for. While Ayadri has been claiming for a breach of territorial sovereignty, the measures which they are requesting are to prevent Rianshan from exercising its right to submit the evidence before the arbitration tribunal. We have further dealt with this issue in page number 13 of the arguments advanced section. Thus, we finish our first limb by submitting before this court that all the rights which are asserted by Ayadri are not plausible, neither are they linked to the measures requested by them. At this point, Your Excellencies, are there any questions that I can satisfy the bench with?
Oh, isn't it really a dispute which one is concerned with? Because what the other side has argued is that in Article 17, it really talks of a dispute. Now, so far as the dispute is concerned, preliminary one has to show that there is a dispute between the parties. Thereafter, one has to go into whether there has actually been a violation of the sovereignty. So therefore, firstly, you have to set, if prima facie there is a dispute between the parties, which can even be with regard to cyber warfare, that would be sufficient to attract the jurisdiction of this court. What do you have to say with regard to that?
Your Excellencies, if you turn your attention to article number 17, it begins with the statement, to avoid a repetition of circumstances that brought about this treaty. These circumstances refer to the border dispute which happened in 1960s. Cyberspace is not concerned with such disputes alone. So it is our submission that these disputes which Article 17 talks about refer only to border dispute. For example, if something happens at the LFC and not regarding cyberspace, Your Excellency. If that satisfies your question, Your Excellency, I will move to the next submission of Ayadri, which is the applicants have submitted that there is a risk of irreparable prejudice and urgency. We respond by submitting before this court that there is no risk of irreparable prejudice and urgency. Your Excellencies, according to Article 41 of the ICJ Statute, this court does not indicate provisional measures when irreparable prejudice does not exist. Now, according to recent orders in provisional measures, prejudice to a state right is said to be irreparable if and only if, without indicating the said provisional measures, it would be impossible to restore the status quo. Now, Your Excellencies, further, this power should be exercised only if there is a case of urgency, in the sense that a real and an imminent risk of irreparable harm will be caused. Now, in this regard, if we relate it with the facts of the case, we submit before this court that there is no urgency in the case at hand. Neither is there a risk of irreparable prejudice. If you refer to paragraph number 34 of the Moot problem, the arbitration has already progressed to an advanced stage. The parties have already finished their pleadings. Furthermore, the oral pleadings have been postponed to March. In the last paragraph of page number 17 of their written memorial, the applicants have expressed a fear of the documents leaking out and affecting the status quo. Further, Speaker 1 also talked about that Rianshan has provided assurances that we will no longer be sharing the documents. However, the fact remains that Rianshan received these documents from an anonymous source, which also means that there can be many other parties out there who are in possession of these documents. So to say for say, the documents are already out there in the external domain. Further, according to the order of this court, which was given on the 15th of September 2021, Rianshan has been asked to refrain from using these documents till the further fulfillment of this case. So the fears that the applicants are possessing and telling that we will leak these documents do not exist, Your Excellencies. On the other hand, Your Excellencies, if Rianshan is allowed or not allowed to submit these documents before the tribunal, it is Rianshan's rights which will suffer an irreparable prejudice. These documents reveal the conspiracy of Ayadri to destroy Rianshan's economy. Rianshan simply seeks compensation for our businesses which suffered. Thus, it is our submission that there is no urgency at all. Now, even if according to the applicant's own Cyber Command report, which is again, let me take this attention, it is very prone to bias as well. The damage which was caused by the cyber attacks were entirely non-physical and could have been reversed. In the pulp mills case of 2010 before this court found that mere financial damage does not constitute irreparable prejudice. There has to be a harm or a risk of harm to the life or the physical integrity of humans. In this case, the only damage which was received were to the firewalls, and there was no loss of functionality according to the agreed statement of facts. Finally, Rianshan is well within its right to submit the documents in the ongoing arbitration proceedings. At this point of time, I will also like to draw the attention of this court to the Timor-Leste case, which the applicants heavily relied on. We feel that in a way, it misled the court, because I will say 2 points here. Number one, the Timor-Leste case was strictly a physical one. The agents of Australia took the documents physically after providing an arrest warrant. Number two, Australia clearly accepted their role behind the attack or behind the seizure of the documents. But here in this case, that is not happened. It is our submission that Rianshan received the documents from an anonymous source. And number two, even if we consider the applicant's point of view that these documents are procured illegally, Your Excellencies, in the Kufu Channel case, it was held that mere admission of documents which have been procured illegally do not constitute or is not a problem, because this court merely uses those documents to answer the question before the law. Admitting these evidence does not legitimize the illegal process in which they were accepted. Thus, Your Excellency, it is our final submission that there is no risk of irreparable prejudice and urgency. Unless we can satisfy Your Excellencies with any further questions, we rest our case by submitting that Ayadri's urgent request for the provisional measures must not be granted. Our prayer is on record. Thank you, Your Excellencies. It was an absolute honor to argue before this court.
Thank you very much.
Yeah, thank you.
Rejoinder, rebuttal?
Yes, Your Excellencies. Just a couple of points. First, respondents still have not satisfactorily addressed the distinction between jurisdiction and the merits. And this court has had a long-standing practice of distinguishing the two, and they have cited to no case where this court has addressed the question of state responsibility and attribution when it is adjudicating on jurisdiction. Just to take one example from a leading case, in the Nicaragua case, for instance, the court, in its 26th of November 1984 judgment on jurisdiction, merely addressed the question of subject matter jurisdiction as to whether the claims give rise to certain jurisdiction, and then on 27th of June 1986 addressed the question of whether the United States whether the actions were attributable to the United States. This distinction has long been drawn, and a contrary finding would deprive the language of Article 17 of the treaty of all meaning. It refers to disputes regarding territorial sovereignty breaches, not violations of territorial sovereignty. Second, whilst respondents accept that physical destruction, for instance, could amount to territorial sovereignty, that loss of functionality could amount to territorial sovereignty, it has no dispute, and it has not rebutted anything with respect to the drone being physically destroyed and the firewall being functionally disabled. Thirdly, we know of no jurisdiction where merely the fact that a judge and an expert witness or a lawyer, having worked at the same firm many years ago, would in itself give rise to any reason to recuse. There must have been something additional, like having worked at the same case or some other connection, and that's just simply not on the record. And secondly, as Your Excellency pointed out, who cares? Why do we care that the judge has to recuse? The only reason we might care is because of a lack of quorum. And as we have submitted to you, the use of an ad hoc chamber would satisfactorily address that concern. Now, respondents suggest that this would take a long time, that this would somehow hamper the court's adjudication. Your Excellencies, an ad hoc chamber has even fewer judges than a full chamber. There are less judges. It would take even less time, and there will be no concerns as to delay if this court were to form an ad hoc chamber. Thank you, Your Excellencies.
Thank you very much.
Thank you.
Your Excellencies, can we have just 30 seconds to respond to the
At
rebuttal?
some point, arguments must stop, whether it's in a moot court or in court itself. This can't go on indefinitely. We'll be here all night.
Much
all right.
obliged, Excellency.
Thank you very much.
Thank you.
Riyaz, just
Yes.
take this offline. I'll call you in a minute.
Yes, I'll just disable my this.
I've sent in my form.
All right, sir. I'll just check and let you know.
You should have it.
We've got it, sir.
Yes, I sent mine. I sent my form.
All right, sir. We'll just check.
Have you received it?
They're just checking.
Yes.
Yes, sir. We've received it.
Yes. Thank you.
Thank you, sir.
You want to announce the results first, or should we speak briefly first?
Yes, sir. We will start with the valedictory function now. Thank you for a very good round to both the judges and the teams. The team that represented the applicant, Team F, is from the University of Oxford, and the Team K is National Law University, Odisha, represented by the respondent. It is evident that both the teams have researched sincerely on international law to argue before this distinguished bench. I would now like to invite our principal, Dr. Asmita Vaidya, who has been a pillar of strength and source of support to the Moot Court Association, to kindly address the audience.
Thank you, Anushka. Ma Saraswati La Vandan. Honorable Mr. Justice Riaz Chagla, sir. Honorable Justice Gautam Patel, sir. The Chairman of Governing Council, Government Law College, Mumbai. Trustees of the DM Harish Foundation. Esteemed professors who are present here. Participants and my beloved students. Government Law College, established in 1855, currently in their 167th year of its glorious existence, has enriched the legal fraternity with some of the best legal minds. The Government Law College has been affiliated to Mumbai University since 1860 and is the oldest law college in Asia, as we all know. It was an honor to host the 23rd Harish International Online Moot Court Competition, India's first international moot court competition. This moot is renowned all over the world for the quality of the judges, the participants, and the compromise. Over the years, it has seen the keen participation of a number of teams from all continents. Just like the past year, this year too, the compromise of the competition dealt primarily with issues relating to public international law, highlighting the armed conflict on international investment and sovereignty over cyberspaces, and was drafted by experts in the field. I hope the participant must have enjoyed the same. I would like to thank honorable judges for gracing us with their presence and finding time to judge the final round of arguments. I thank the trustees of the DM Harish Foundation, Mr. Anil Harish, Mrs. Shobha Jaktiani, Mr. Harish Jaktiani, Mr. Sharan Jaktiani, for their continuous support in making this competition a success. I congratulate the Moot Court Association on successfully conducting an international Moot Court competition on a virtual platform by understanding the harsh reality of COVID-19 pandemic. And lastly, I would like to appreciate and thank the participants for all the hard work they put in to do their best in this mood and provide us with such entertaining and insightful rounds. I congratulate the winners in advance and appreciate their efforts. We hope that you must have enjoyed the experience, and we hope association will be continued. I personally hope to see you again next year, not virtually, but physically. Thank you. Thank you very much.
Thank you, ma'am. This competition is indeed a fitting tribute to the late Mr. DM Harish, in whose memory it is hosted. The trustees of the DM Harish Foundation have over the years established a bond with this college, which goes beyond just this competition. Mr. Anil Harish, Mrs. Shobha Jaktiani, Mr. Harish Jaktiani, Mrs. Harish, and Mr. Sharan Jaktiani have been present with the Moot Court Association through all its endeavors. I would now like to request Mr. Anil Harish to kindly address the audience.
Honorable Mr. Justice Gautam Patel, Honorable Mr. Justice Riaz Chagla, Principal Dr. Asmita Vaidya, Professor Sonali Mathur and Professor Keshu Daswani and other professors of GLC, Mr. Abhishek Raj and members of his team, fellow lawyers, fellow students, because we must remain students all our lives, and distinguished ladies and gentlemen. Last year, this Moot Court competition moved into cyberspace, and this year too continues to be accessible to and have jurisdiction over teams from everywhere. We are honored by the presence of Honorable Mr. Justice Gautam Patel and Honorable Mr. Justice Riaz Chagla. For both, today has been a working Sunday. We are very grateful, Your Lordships, for all your time and your support to this Moot Court competition, and for your study and your probing questions, and your contribution to education, and for inspiring all of us with your dedication. Many senior counsel and advocates have so willingly come forward and judged the rounds, and I thank them very much. The case itself was excellently drafted by Mr. Pratik Bagaria, advocate. It was a challenge not only to the student advocates, but also to those judged, as it contained many complex facts. But this itself is a learning experience, as in real life, to comb through history and a mass of facts, and then to focus on the critical issues. I am grateful to the lawyers who judged the memorials submitted by the teams, Ms. Divya Alexander, Mr. Ruju Thakkar, Mr. Karthik Jaykumar, and Ms. Fatima Ansari, and to the students who authored the bench memorial, Ms. Anushka Mani and Ms. Sakshi Shetty. The student advocates from universities and colleges from all over India and from the University of Oxford have been brilliant. I can only imagine the many hours of the many days of the many weeks that they have spent studying the problem and doing research. I am sure that the ability to prepare so thoroughly has become a part of your psyche, and that it will stand you in good stead in the future. So even if you do not get a prize, remember that in education, everyone is a winner. The moot court competition has been organized so well, as always, by the GLC MCA, with a constant and positive support throughout the year of the principal and the professor in charge, Ms. Sonali Mathur, and Professor Kishu Daswani, other professors and staff of GLC. We are very grateful to them. The members of the association, headed by Mr. Abhishek Raj and assisted by so many others, have worked very hard and have attended to every detail in coordinating the competition, preparing a souvenir and bench memorial, and comparing. All of you are truly special. The real value of this competition is to show that barriers must be broken, and students and all of us should see that mutual help and cooperation is the only way forward. I hope these interactions this year virtually and in future again physically will help us to understand each other and the different points of view and to build bridges. Winston Churchill said, "The empires of the future are the empires of the mind." That is even more true today than when he said it. And I'm sure that the tremendous minds we have witnessed of judges, participants, and organizers can truly shape the future and lead to greater international understanding and make the world a better place to live in. Thank you all.
Thank you, sir. Honorable Mr. Justice G.S. Patel is a graduate of St. Xavier's College and Government Law College. He started practice in 1987 in Mumbai.
Hold on. We'll let Riaz go first.
All right.
All right, sir. Honorable Mr. Justice R.I. Chagla completed his graduation from HR College of Commerce and Economics, Mumbai University in 1991. Graduated in law in the year 1993 from the University of Cambridge, Downing College. He practiced as a counsel in the Honorable Bombay High Court for over 23 years and also appeared in the Honorable Supreme Court of India. During practice as counsel, he appeared in civil, constitutional, commercial, corporate, intellectual property, taxation, and testamentary cases. He also appeared and acted as an arbitrator in several arbitrations. He elevated as the additional judge of Bombay High Court on the 5th June of 2017. I would like him to address the audience.
Yes, I would like to start by thanking the trustees of the DM Harish Foundation, in particular Mr. Anil Harish, Mr. Sharan Jaktiani, Mrs. Jaktiani, and Mr. Harish Jaktiani, and all the family for their encouragement in this and for inviting me to judge this moot court, international moot court competition. It's indeed been a privilege to judge the competition, and in fact, once again associate with the Government Law College Principal Dr. Asmita Vaidya and Professor Sonali Mathur and Mr. Kishu Daswani, who do so much for mooting in the Government Law College. In fact, my grandfather's trust, the MC Chagla Memorial Trust, also has a national moot court competition, which we hold every year. But this is one level higher, which is, of course, an international moot court competition. And it does encourage participants from all over the world. And I'm glad to know that Oxford University, in fact, has sent a team, and which ultimately did make it to the finals. Well, I would say that both the teams were good. One team, of course, was better. That's why we have scored them higher, and they have won the competition. But what I would like to say is that international moot court competitions take it to another level. Our Indian colleges are also pitted against the best of the moot competitors from all over the world. And in fact, whether it is United States, whether it's England, it encourages teams from all different parts of the world. Well, Justice Patel and myself found it difficult, but we ultimately had to score one team, and it was indeed a very tough competition. And the moot question was increasingly interesting for, at least for me to read, because, it concerned cyberspace, it concerned, all sorts of issues. It concerned a border issue also, which China and India had entered into, and in fact, just a short while ago. And we lost some of our soldiers. China lost some of their soldiers, and it in fact had an interesting bearing on various levels. And what I would like to say is that the person who's written this, the Moot question, I compliment him because he's done a tremendous job. Well, I don't want to talk for too long. I mean, I'm sure you'd like to hear Justice Patel, and he's always very interesting. I would just like to thank you once again, and wish all the competitors who competed in this competition all the very best. I do hope to see them at the bar and ultimately appear before us judges. Thank you very much. Thank you.
Thank you so much, sir. Honorable Mr. Justice J.S. Patel is a graduate of St. Xavier's College and Government Law College. He started practice in 1987 in Mumbai, working on commercial, corporate, and civil litigation, and also appearing in a large number of environmental public interest litigations, including those relating to the Sanjay Gandhi National Park, protection of mangroves, town and country planning issues, Melghat National Park, the mill lands, protection of open spaces, etc. He was sworn in as a judge of the Bombay High Court on 21st of June 2013. I would now like to thank him for his presence as a judge in today's moot court competition. I would now like to request Honorable Justice J.S. Patel to address the audience.
To the DM Harish and Jagtiani families, thank you very much for inviting me. Dr. Vaidya, it's always a pleasure. Our standards keep going up, and there has been a vast improvement recently under your stewardship. So thank you very much for that. Before I go further, I think real expression of thanks to those who worked in the background. Over the years, I've seen the DM Harish International Moot brief and the problem growing in complexity, adding layers and layers to it. It's now at a very different level. Having said that, I do have a confession to make. I absolutely hate these DM Harish moots for two reasons. The first is that it's a constant reminder of my inadequacies, and a reminder that if I've become a judge, it's more a question of luck than ability when compared to what we see before us in this competition. The standard today was so astonishingly high. And that's the second part of it, which is that there's a great sense of relief that I'm not in competition with any of you people. I mean, thank God for that. I don't think I would have been able to match this level of advocacy or this skill in organizing arguments. And please, everyone, let's have a round of applause for the researchers for all the work they've done in what are exceedingly difficult and complex cases in international law. The standards this evening were exceptionally high, as my friend and colleague, Justice Chagla said. Well, somebody has to win officially in terms of scoring points. But as Mr. Harish said, nobody here is really a loser. Everyone comes out on top because you've participated. And one of the things that you will find here in law as you go along is that every day you wake up just another student of the law. And that's part of the learning process in any case. So very well done. I think the cyber form may have actually been a sort of blessing in disguise to be able to facilitate more teams from across the world. But there's no substitute for being able to meet you in person. I wish we could have done that and could have met with you and interacted with you. So perhaps next year we'll be able to do it at the next round. Thank you very, very much, and well done again.
Thank you for expressing such kind words, sir. We will now announce the results of the competitions. All the winners will receive a cash prize and digital certificate.
I would request the principal, Dr. Asmita Vaidya, to announce the award for the second best memorial.
You're muted, Dr. Vaidya.
Yeah, yes, Sakshi. The second best memorial goes to Team D, School of Law, Crest, Bangalore. Hearty congratulations to them. And the winners are Vishnu Mohan Naidu, Rahul Rajeshekar, and Asiri Raj. So I congratulate all the three. Congratulations.
Thank you, ma'am. Now I would like to request Mr. Anil Harish to announce the award for the best memorial.
The winners of the prize for the best memorial are Team A, Rajiv Gandhi National University of Law, Punjab. Pratham Malhotra, Pravetna Sulakshya, and Raghav Sehgal. Congratulations.
Thank you, sir. I would now request Mr. Anil Harish to announce the award for the best speaker in the final round.
Am I to announce this? The best speaker in the final round?
Yes, I believe so.
Yes.
The best speaker in the final round is Angelo Ryu from the University of Oxford.
Well done.
Congratulations.
That was extraordinary.
Thank you.
I would request His Lordship Justice Chagla to announce the award for the best speaker and the second best speaker.
Well, the best speaker goes to Rahul Rajeshekar from School of Law, Christ, Bangalore. Is that correct? That is Ms. Pani, I've just received that. Is that right?
Yes.
Yes. So Rahul Rajeshekar from School of Law, Christ, Bangalore. And second best speaker is Angelo Rio from the University of Oxford. Yes.
Thank you, sir. I would request His Lordship Justice G.S. Patel to announce the award for the runners-up team and the winning team.
The runner-up team is Team K, Rohini Roy, Suvanesh Das, and Pratiksha Mohanty of the National Law University, Odisha. And the winning team is Team F, Angelo Ryu, Oliver Hutton, and Lester Ho of the University of Oxford. Well done, all of you. It was a really, really impressive performance all around.
Thank you, Your Lordship.
Congratulations to the teams. We have now come to the end of the competition. The Moot Court Association of Government Law College has been organizing around 8 moots per year since its inception in 1954. It is a well-established committee which is managed by the students with the help and guidance of all professors and staff members of Government Law College. The General Secretary, Mr. Abhishek Raj, and the Assistant General Secretary, Mr. Ruhan Shah, have not only been great mentors, but have also helped this committee grow and encouraged its members to develop the quality of leadership. We would now like to invite our Assistant General Secretary, Mr. Shah, to deliver the vote of thanks.
Thank you. Honorable Mr. Justice G.S. Patel, Honorable Mr. Justice R.I. Chakla, Mr. Anil Harish, Dr. Asmita Vaidya, the trustees of the D.M. Harish Foundation, Professor Sonali Mathur, participants, ladies and gentlemen. It has truly been a privilege for the Moot Court Association of Government Law College to organize this competition annually in memory of the late Mr. D.M. Harish, a GLC alumnus and one of the greatest taxation experts that India has ever seen. The growth and progress of this competition as one of India's finest international moot court competitions bears testimony to the constant support, encouragement, and dedication of a number of people. And this competition would be incomplete without acknowledging their efforts. The Moot Court Association of Government Law College is indebted to Honorable Mr. Justice G.S. Patel and Honorable Mr. Justice R.I. Chagla for sparing their invaluable time. We sincerely thank them for gracing us with their presence and for consenting to judge the final round of arguments. I would also like to thank Mr. Anil Harish for his constant support as both a judge and a trustee in several of the Moot Court Association's endeavors. This prestigious event is truly an outcome of the broad vision of the DM Harish Foundation. I take this opportunity to thank all the trustees of the foundation, and in particular, Mr. Anil Harish and Mrs. Shobha Jagtiani, for their steadfast faith and support in the Moot Court Association. I extend my heartfelt gratitude to Mr. Harish Jagtiani, Mrs. Hani Harish, and Mr. Sharan Jagtiani, the trustees of the DM Harish Foundation, for their persistent belief in the association. I would also like to sincerely thank Mr. Adhiraj Harish and Ms. Rishika Harish for all their help in making this competition a success. I sincerely thank our principal, Dr. Asmita Vaidya, Professor Rachita Ratho, Dr. Umesh Aswar, Professor Kishu Daswani, and Professor Malika Devendra for supporting us through our endeavors and encouraging us constantly. The unwavering efforts of Professor Sonali Mathur have also always helped this competition see a brighter future, and her vision has greatly built this competition into what it has become today. I would also like to thank the advisory board of the Moot Court Association, consisting of Mr. Ruben Vakil, Mr. Feroz Patel, and Mr. Shanay Bafna. Last but not the least, I would like to thank each and every member of the Moot Court Association for their undying dedication and hard work. This competition would not have been possible without their commitment. In particular, I would like to thank the office bearers of the association, Abhishek Raj, Riya Doshi, Riya Nari Chanya, Benaisha Hansotia, Aman Saraf, Rajveer Veera, Shreya Bora, Sakshi Shetty, Anushka Mani, Lubaina Sotarwala, and Muskan Dadia for their vital contribution in making this competition a reality today. I would like to extend my gratitude to all the teams, both domestic as well as international, for participating in this competition. I hope this was an enriching and enjoyable experience, and I truly hope to host you, hopefully in person, sometime in the near future. Thank you and good night.